So guys, thank you so much and karibu sana kwenye YouTube channel yangu Daniel ONSARE NYAGAKA, and of course tuko kotini where Jimi Wanjigi's case is happening, and we're waiting because it was supposed to start from around 2 p.m. So we're here still waiting for whatever that is happening, and yeah, so as we wait, naomba msubscribe, naomba mshare, and yes.
Oh, you're at, okay. Tell her that we sent to her. Yeah, I need to talk to her. Tell her it's calling her today. No, it's that problem. Mambo is a sharing. 396. Madam, you're saying you not yet received from your colleagues, but they are specifically going to inform you. Wanjigi. Kazi haijaanza ama mama mnachukua
milimani. Hayo ni milimani. Jimi Wanjigi,
I've joined my team. Yes, the order strong and the high court. And I would prefer that I leave it to him to explain to the court what actually happened.
Really nice to see you. We did appear before Senior Justice Bahati Mumwe in the morning, in which the issues that are coming up
first instance was the contemptuous manner in which the respondents, the applicants in this before you, were arrested in violation of the court order. The court took it very seriously that there's an attempt to commence criminal proceedings in a manner that ipso facto is contemptuous of its own order. You ignore my orders, then you those proceedings. And Your Honor, the court did issue an order that the contempt by Mr. Masenge, Mr. Amin Mohammed Hussein, and Mr. Sang Michael, who superintended over the disobedience of its orders, must be dealt with before anything else happens, even in that particular file. And to show the seriousness with which the court took this issue of disobedience of court orders, the court did issue an order in the following terms: pending the full inter partes hearing and determination of the interlocutory applications pending in the file, a conservatory order in the nature of an order of prohibition be and is hereby issued against the second respondent, that is the DPP, barring the second respondent from profiling or instituting any criminal charges or continuing any criminal prosecution against the petitioner as the subject matter of the petition hearing. And because sometimes the state says they don't understand court orders, the court proceeds to provide that for added clarity, so that we don't leave it to chance, the petitioner shall not take plea before the subordinate court during his appearance of 26th September 2024. I do believe that my married colleagues on the other side, as opposed to their clients, then they are obedient obeyers of the court and its processes. They respect the law. So that, Your Honor, settles the issue of the ruling that we're coming to ask you to arrest in relation to the first charge sheet. In relation to this, and that's what I own.
By first charge sheet, you mean
The one on the felony charges. It's set.
that's to be 37 of 2024.
Yes. 837, yes. It is.
The one for the felony is 836.
836. So that settles that particular matter. And in relation with the order is on the court file, in relation to the firearms charges, again, that matter came up in petition E427 before the same day. But at least for once, we were able to report to the judge that there was no contempt application The state has respected that order so far. But just so that we don't lose focus, interpretation, the court issued an order that the orders dated 20th August 2024 in terms of orders number 2 and 3 are confirmed. They are confirmed and extended pending the full hearing and determination of the petition, and proceeds to, just so that they don't misread or misinterpret, the court proceeded to say, and that is up to, and including the date of judgment in this matter. And that, Your Honor, settles the question of the proposed charges in E837 that was before you, until the High Court will issue its judgment. We will supply the copy of that order to the court, to my colleagues. And my Honor, just for the information of the court, the contempt application will be coming up before the court on the 4th of October for further directions on how the court will deal with the contemnants, those who don't believe in the rule of law. They have their dates before that judge to answer.
When is the date is that?
4th of October. That's when the contempt application will come. But without belaboring the point, Your Honor, at this point we are only but left with one option, and that option is to preserve judicial ink and stop the proceedings. The theater of litigation now moves to the High Court. We can use judicial ink at the High Court, and subject to what that court will say, we'll come back to you. And as I proceed to sit, Your Honor, we only have but one application to make. The High Court, having stayed these proceedings by issuing conservatory orders, will pray, Your Honor, that the passports of the applicants be released to them, Mr. Wanjigi is due to travel out of the country to take his daughter to school. He has missed the first 2 weeks because of the tribulations caused by the state on the family. And that, subject to the court's discretion, they can equally be discharged for the personal bond that they had committed to court. My senior Dr. Kamila.
Above all, I must thank the High Court. Sitting this morning, us suggest the issue in very strong language. Your Honor, you will permit me if I say a few things about court orders.
We need to go into that council.
Your Honor, please would you let me say something about court orders?
Because what, very short.
I'll be
In a
very
very
brief
short
on
time, because
I'll be
now
very
we are through with what you wanted to say.
Yes, I'll be very brief, Your Honor.
Yes.
Your Honor, I'm a full-time court lawyer. I don't do anything else in this country other than appearing in court very much. There is an unfortunate culture of disobeying court orders. There are certain individuals in the executive who have absolutely no respect for court orders made by magistrates, and by judges. And Your Honor, I've been the bar for a long time, for many years. This culture exhibiting arrogance, exhibiting impunity, process of the law. They have no respect for orders of the court. Your Honor, permit me to state the following. I was around during the era of the trade when Charles joined us. Orders of the court were obeyed. Nobody ever talked about disobedience. In ceremony, when he was president, apart from one or two things, which was impunity exhibited, court orders were obeyed. There was no arrogance. During Muslim Kabaki, break, court orders were obeyed. We had no. But during the reign of President, court orders were not obeyed at all. I kept on the court orders, and we had an internal security minister who exhibited such arrogance. He thought he was the only person who had received education in Kenya. He never disobeyed, he never obeyed court orders. He created court orders and stored them. In the Roman world, they had saved God. Your Honor, only by obeying court orders that we maintain the rule of law in the country. By obeying court orders, you maintain rule of law in the country. Your Honor, I have with this Wanjigi, right from the time we had we appeared before the CID headquarters. We were treated like a taka. No respect whatsoever. That's why you heard me this morning pleading with you that we must make sure that we respect one another. The magistrates subordinate court should respect the High Court. So that even if the High Court had not issued the orders the defendant has now read to, I would have pleaded with you.
We've had you, Senior Counsel, thank you. We've had you.
Thank you
I
very much.
wanted to listen to what the prosecution has to say,
Yes, sir.
in case they want to say anything.
I just want to add, Your Honor, that in terms of the orders that caused the arrest, those orders are still in force, and those orders are subject to the contract application because they are the orders which are disobeyed.
Which orders are these?
These are the orders issued by the High Court
Yes,
on the 9th of August.
they are the orders that you are confirming.
No, they are the earlier ones. The ones I've given you today were issued late. Yes. Those are the orders subject to the content application before the court. They are still in force.
When I looked up some law, if you may permit me to show it to you. I looked up some law for, as a lawyer, I like talking to some lawyer.
Yes, we'll have a look at them, but for now, because we have other matters ahead of us, and we've given you the chance to say something, Counsel, submit, we read.
I should get to it.
Yeah, we read at our own time.
Yes.
Yeah.
Your Honor,
Just give to, you can give to my court assistant.
yeah, just let me say one or two things, Your Honor. Your Honor, in the authorities before you, I have tried to show that without even getting the orders my friend has given, you would have given respect to the High Court.
Your Honor, we submit that there has been no change of circumstances. Warranting review of motions. Your Honor, I submit that in such an application, the applicant is under duty to convince the court that there has been a change of circumstances. Your Honor, no material evidence has been placed before this court to demonstrate that indeed there is an urgent need for the suspect to travel outside the country, and that is, he will be leaving this court's jurisdiction. No sworn affidavit has been filed in court, and no supporting documents have been filed. Your Honor, I therefore submit that this is in the interest of justice for the bond terms be maintained. We urge this court to dismiss the application and maintain the status quo.
For a brief response, the DPP has been told by the High Court not to proceed with any prosecution. In fact, the order is not even an order to stay. It's not even an order on the file. It's an order telling the DPP not to proceed with any prosecution. In other words, they were stopped from instituting, but if they attempted to start, they've been told, stop it, stop it. That's what they've been told. In those circumstances, the terms which this court had imposed when issuing bond have been affected by that order. To the court to make full disclosure. To the court to make full disclosure. Because as it were now, nothing can happen on that file. The High Court is seized of it. And is not an accused person. We don't have before you an accused person. He is not an accused person. He has not taken any plea. The state did not even argue on whether bail or bond should be given when those terms were imposed by the court. Because there was no accused person before the court. What was there was a proposal. I would shudder to think what will happen to the liberty of individuals if the state were to take the position taken today, that any time that I imagine I'm going to prosecute you, the court should give me an order to detain your passport. No. We do pray, Your Honor, that in light of the developments in the High Court, which are not minor, these are major developments in the High Court, that at the core of it even has the liberty of the Inspector General, Masengeli, the DCI, Amin, and Mr. Sang. Those cannot be wished away as no change in circumstances. Those are substantive change in circumstances. And that this court having bonded the suspects in advance because of the ruling that the court had reserved. This court cannot even issue that ruling anymore. It cannot issue that ruling anymore. Because the bonding was pegged on the ruling, the outcome of that ruling. Now the High Court has taken over the conduct of the matter. That ruling cannot even be issued. So everybody goes back to the position status quo before we came before you. And my learned colleague should not confuse this particular instance and incidences with where an accused person has taken plea. No plea had been taken. What you